Good evening, everyone. We're going to go ahead and get started this evening. This is the City of Deltona code enforcement hearings before the special magistrate. This is the 28th of July, 2021. It is 5:30 in the evening. We start out our meetings with a roll call. I'm going to introduce myself first. My name is William Reichman. I'm an attorney, and I've been appointed by the City Commission of the City of Deltona to act in the capacity as a special magistrate, which is basically just a hearing officer to hear the cases that are being brought forward this evening on behalf of the City of Deltona by code enforcement officers. And now, if everyone, all the officers and everyone else could introduce themselves for our roll call.
Angela Meyer, hearing clerk.
Richard Lovett, Code Compliance Supervisor.
Mark Gibson, Code Compliance Supervisor.
Byron San Miguel, Code Compliance Officer.
Yes, we
Mary Mercy, Code Compliance Officer.
Steve Brokoff, Code Compliance Officer.
Is it over to our side? Ron,
Go ahead.
oh, Marcia Siegel George, City Attorney.
Ron Paradise, Planning and Development Services.
Everybody?
Merced, Lean Legal Assistant.
Sorry. You snuck in there. I didn't see you over there in the corner. Sorry about that. I think that's everybody. Okay, the next thing we're going to do, we're going to go ahead and stand now and pledge allegiance to the flags, please. Please join me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Just a little bit about our process. These hearings this evening are heard by myself as the City of Deltona's Code Enforcement Special Magistrate are established and held pursuant to and consistent with the Florida Statutes, Chapter 162, as well as the Chapter 2 of the City of Deltona Code of Ordinances. These hearings tonight are quasi-judicial. They require notice, and they require an opportunity to be heard. And I will certainly provide that to everyone this evening. These are not courtroom proceedings, but fundamental due process shall be observed. I will be taking judicial notice of the City of Deltona Code of Ordinances, state statutes as applicable and appropriate, Florida Building Code, and the International Property Maintenance Code. This evening, if you wish to submit any documents for my consideration, please understand that they will become part of the record, meaning they'll become the property of the city. They'll be made part of your official case file. Florida law, actually the public records law, will require that they be kept, and they'll be subject, if requested, to public review. So these documents will not be returnable. Should you wish to receive copies of your documents, please direct your requests to the hearing clerk. Okay. I want everyone to know, both city representatives and those that are here this evening on your cases, that I have not had any what's called ex parte communications, and what that means is that I have not talked to anyone about any of these cases. So I'm going to make my decisions this evening based upon only what I hear this evening and what I'm shown this evening, the evidence that I received this evening. Next, I want everyone to know that as far as the meeting minutes go of June 23rd, 2021, I've reviewed those and I have approved those. Let's see, announcements. We have some cases that have been withdrawn. I want to go ahead and so if you're here on those, then I'll announce those and y'all can go home. DEL 21067, it's a Massey case, property address 2502 Shiprock Court. That has been withdrawn. Let's see, DEL 21087, property address 2187 Howland Boulevard, withdrawn. DEL 21091, property address 1240 Providence Boulevard, withdrawn. DEL 21097, property address 932 Hemingway Drive, withdrawn. DEL 21107, property address 2187 Howland Boulevard, also withdrawn. Okay, We're about to get started with our first case, so in order to do that, I need everyone who will be providing testimony this evening or asking me to consider your testimony. At this time, I need to swear you in. So if you're going to give some testimony, please stand, raise your right hand. Do you swear or affirm that the testimony you provide this evening will be the truth, the whole truth, and nothing but the truth? When your case is called, folks, the way we do this is it's the city's responsibility to prove their case, so they're going to go first. So when you hear your case called, know that the first thing that I'm going to hear is going to be the testimony from the city representatives. When they're done, I want to hear from all of you. And so when it's your time to come and speak, if you could come forward, and I believe we have a spot right there in the middle, when it's time for you all to testify, to come up right there. That way I can hear you and it'll be recorded, so we'll know exactly what you said. Okay, the first case, let's see, DEL 21048, I believe. Let me look at this real quick. Oh, hang on just a second. Yes, DEL 21048. This is a Massey case with a property address at 930 Radcliffe Street. City ready to proceed?
Just as soon as I figure out where to put the stick.
I'm sorry.
For the pictures?
Go.
1 second.
And the city's ready?
Please proceed, officer.
This case DEL 21...
Could you identify I'm sorry.
Oh, my name is Steve Brokoff. I'm employed with the city as a code compliance officer. This is case DEL 21048. The address is 930 Radcliffe Street. And I believe the respondents are present. This case was heard on the 28th of April, 2021, and order was given 60 days to comply because it has a lot of debris in the front and also the back of the property. They were going to move a whole bunch of stuff that was actually in an enclosed area, plus all the stuff around the side, to a facility and contact us. They have not contacted us, and as you can see, this picture was taken recently. There has been no change. They are still scrapping at the property.
So let me understand. Today is the 20...
Well, it's, yeah, and after 6 days, as today, there'd be 31 days at $50 a day for a total of $1,550. And the property is still in non-compliance with virtually no change in their behavior. The city would appreciate the fine to continue.
So let me understand your testimony. You're saying that from the deadline that was provided in my prior order, non-compliance has been for a total through today of 31 days.
That's correct.
And the prior order required or imposed a fine of $50 per day, and the total of that is $1,550.
That's correct.
And these pictures were taken...
on the 11th, I believe.
Have you had any contact with the property owners?
No, they were supposed to contact us and let us know when they had cleaned up, and nothing.
Okay, but let me say, this photo right here is representative of the condition of the property?
Yeah, and also, let me, and it's also in the front too. Even when I went to post the
Has there been any efforts made? I mean, have there been any improvements?
No, there hasn't been any improvements. It goes in various degrees of they'll start to clean up a little bit and then bring in a whole bunch of other junk.
Okay.
There has been no change in behavior.
Very good. Anything further?
The city doesn't have anything further.
Is there anyone here representing the property at 930 Radcliffe Street?
And I believe we have an interpreter that could help out, Gladys.
Okay. Would you ask him, please, to provide his name and address, please, for the record?
Honorio Hernández Cruz,
This-
930 Rock Street.
As I understood the gentleman to say, he is the owner, Honorario Hernandez.
Usted es el dueño, señor Honorario Hernández.
Sí,
Yes, sir.
Thank you. Sir, ask him if he understood the testimony of the officer.
¿Usted entendió el testimonio del oficial
de
cuando
cual-
él estaba leyendo su testimonio?
no.
No, he didn't.
Okay, here's what I'm going to try to summarize it so that he'll understand what's going on. Would you let him know that there was a prior order requiring him to clean up all the debris off his property?
Anteriormente hubo una orden donde usted se suponía que limpiara los alrededores de su residencia.
And that order had a deadline for compliance.
Y esa orden tenía una fecha límite para usted poner todo en orden.
And based upon the testimony of the city, the property was not cleaned up by that deadline.
Y basado en el testimonio de la ciudad por el oficial, la residencia suya, lo que tenía que limpiar, no lo han limpiado.
O sea, está limpio.
And that order imposes a fine per day since that deadline of $50 per day.
Y esa orden conlleva una factura de $50 por día hasta que venga en compliance.
It's been 31 days at $50 per day, and the total fine, which continues to run today, is $1,550.
Desde eso han pasado 31 días a $50 por día, llegando a un total de $1,550 hasta hoy.
Pues si está limpia la yarda.
No entendí lo que dijo.
Que está limpia la yarda. O sea, yo limpié todo.
He said that he has cleaned everything.
Va que no pude sacar el gestazo porque estaba lloviendo.
He said the only thing that's there is a car and he hasn't moved it because it was raining.
Ya, y pueden chequear que está limpio.
And he said you could check to make sure that it's clean, but he's cleaned everything according to his testimony.
And would you ask him, when did he finish cleaning up the property?
Señor Honorario, ¿cuándo usted terminó de limpiar la propiedad?
Hoy,
Today.
parece hoy. Estaba lloviendo.
Okay,
Today.
tell him to hang on a second then. Tell him to hang on.
Un momentito, por favor.
I have a question for the code officer now.
Él le va a preguntar al oficial. Tiene una pregunta.
Officer Brokoff, when did you last go out to the property and inspect it?
I was out there on Monday, but I didn't take, I was in the area for other things. I didn't take a picture. The last picture I took was on the 11th, but nothing has changed. The city is actually considering doing an abatement on the property if the...
Okay, but my question, when was the last time that you had personal knowledge that the condition of the
It would have
property?
been Monday.
Monday, okay, today's Wednesday. So is there anyone here that can refute his testimony that the property's been cleaned up today?
If what we could do is go and do an inspection in the morning, if truly the property is cleaned up, they're still in violation of the 31 days that we mentioned before.
Could you ask the gentleman if he has any, did he take a photograph of the way the property looks today after it's been cleaned?
Señor Honorario, después que usted limpió la propiedad, ¿usted le tomó fotografía a la propiedad?
Por eso no pude tomar fotografía hoy porque estaba lloviendo, pero que ellos pueden ir mañana y ven esto limpio.
Okay.
Con tu
He
umbrella.
said because of the weather, the bad weather and the rain, he wasn't able to take a photograph, but he is willing to allow them to come tomorrow and take a picture, because he said he's cleaned it up.
Okay.
And that's exactly why I wasn't able to take one today. We had a meeting in New Smyrna.
That's fine.
By the time I got back, it was actually hailing.
Okay, here's what I'm going to order. I'm going to find, based upon the testimony that I've heard this evening, that the property was in a non-compliance past the deadline, and it remained in non-compliance through to today for a total of 31 days, $50 a day, at $1,550. But that based upon the evidence presented to me this evening, that it is in compliance now. So if this happens again, it'll be a repeat violation. But also, this will be subject to verification by the code enforcement of the city. So, ma'am, if you could tell this gentleman and his wife that based upon the evidence that's been presented, and the fact that he did not clean it up till today, that there's going to be a fine of $1,550, which is based upon 31 days at $50 per day.
Okay, el licenciado dice que basado en la evidencia y el testimonio del oficial, pasaron 31 días antes de usted limpiar la propiedad. Así que la orden de $50 por día todavía está en efectivo por un monto de $1,550. Y mañana van a verificar si en verdad la propiedad ha estado o ha sido limpia.
Sí.
¿Entiende?
Pueden pasar mañana y chequear, que saquen retrato y chequeen para ver si está limpio o no.
He said you could go by tomorrow and verify and confirm that he's cleaned the property.
Yeah, and that's including the back area.
Sí, pues él pasa acá rato por casa, va para allá y va por lo que se para y chequee, para que si está bien o no está bien.
Yeah, he said, he cleaned it the best he could, and you can go and verify and confirm that he did clean the property.
Oh, we'll verify, but in his earlier testimony, he said that he was going to allow us into the enclosed area and back also.
Usted la última vez dijo que le iba a permitir la entrada a la parte posterior de la propiedad. ¿Todavía está eso?
Sí, puede entrar en la propiedad
He
completa.
said there's no issues, there's no problem.
Oh, yeah, and we can verify.
Okay, a couple things and then we'll be done. Officer Brokoff, could you also let him know what the process is in case he wants to try to come in and reduce the fine so that he'll understand? I mean, don't be his attorney, but let him know that there are options.
Yeah, the options are he has to come before the special magistrate and
No,
ask.
you don't need to tell us. I'm saying when this matter's over, if you could let him know.
Oh, okay. Well, I'm going to have to use the
Yeah,
interpreter.
I know exactly what the options are. I'm pretty sure she does too.
I thought you wanted read into the record.
I'll be
Sorry.
here.
Yeah,
I'm not gonna-
and so, ma'am, if you could tell these folks, thank you very much for being here this evening. Thank you for bringing their property into compliance, and just thank him.
Le damos las gracias por haber venido hoy, las gracias también por haber limpiado la propiedad y ya le daremos opciones al final de la reunión. Y si desean tomar asiento,
Gracias.
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 Thank you.
¿Cuándo tenemos que pagar eso?
She wants to know when they have to pay the fine.
Ask her just to coordinate that with the code enforcement officer.
Okay. Van a tener que coordinar eso con el oficial, que sería al final de la reunión esta noche, si
Ah,
pueden
bien.
esperar.
Gracias. No, está
Officer
bien.
Brokoff, if you could just please let them know how the fine works and what the options are, please.
Él va a discutir con ustedes en las opciones y cómo pueden pagar la multa.
Ah,
Pero
ok.
tienen que tomar asiento y esperar.
Ah, gracias.
We may need an interpreter. We'll find out. Okay, the next case involves 900 Deltona Boulevard. Give me a second to find that, please. Okay, I have that there are 4 cases
Yes, sir, that's correct.
for this property.
Yes, sir. With
Okay,
your
we're going to
permission,
do
I would
them
like
one
to.
by one.
With your permission, I'd like to present them all.
Okay, all right.
If you'd like me to do them one by one, I can. They are smaller code issues, and there has been agreements made with the property owner who is
Okay,
here
yeah,
tonight.
let's go ahead and do them all at the same time. So for the record, we're hearing 4 cases. They all deal with one property, and that property has an address at 900 Deltona Boulevard.
Yes, sir.
For the record, the cases are DEL 21093, 21094, 095, and 096. And for the record, in order, those cases involve 4 different violations: sign in disrepair, driveway in disrepair, electrical in disrepair, and public nuisance. So we've got a lot of disrepair out here.
Yes, sir.
Is the city ready to proceed?
City's ready.
Okay, please do.
Good evening. My name is Myron San Miguel. I'm employed by the City of Deltona as a code compliance officer. My credentials are on file with the city. These are going to be for case numbers DEL 21-093, -094, 095, and 096. City of Deltona versus All American Oil, location address 900 Deltona Boulevard, Deltona, Florida 32725. The parcel ID number for this address is 813-022-210-0110. After speaking with the owners of the property, this is a gas station that has fallen down into disrepair and is now a vacant lot. If you view on the screen, the building itself is in disrepair and is going to be getting fixed and repainted. The graffiti is going to be taken off. The sign that is in disrepair, as seen here, is missing pieces of it and is broken. The what I believe to be the gas drainage section has a cover missing. It's a safety issue that is going to be getting replaced, and the electrical wiring that is open and standing on one of the units is there. After speaking with the homeowners, it was agreed upon, and the city would like to request 60 days to come into compliance to give them time to obtain the permits. It is my understanding after conversating with them today that they have plans in place with contractors lined up, and they're just waiting for the timeline of the engineer drawings and so forth, and then they will be obtaining the permits.
Great. A couple questions. Could you go ahead and put on the record that the city's compliance with the notice requirements?
Yes, sir. The city has noticed the property. The city has sent certified mail the owner, and the city has confirmed with them that they've received them.
Both the notices of violation and the notices of hearing?
Yes, sir.
Okay. And just for the record, I see the photographs and I understand the violation regarding the sign, the driveway, and the electrical. I'm curious, what is the violation that would support for me to find that there is a public nuisance out there? These are four separate violations, so I mean, I need to make,
Yes, sir.
have in the record findings for each one of these separately.
Yes, sir. Give me 1 second.
Mr. Reichman, I can probably answer that, Richard Lovett. The one for the public nuisance is for the building being in disrepair from being a burnout. They had a fire there like 3 years ago, and they have been trying to get it repaired, so that's what the public nuisance is for the blight.
So what the city's asking me to find is that for these four cases, the city contends that they are currently in violation, and that the city would request that I give the property owner 60 days to comply, or a fine in the amount of?
$50 a day.
Okay. And you have met with the property owner? And,
Yes, sir.
And that is something that they, are they here?
They are here today, and I apologize for not having that information.
No, that's okay.
I'm standing in for Officer Dennis Muse.
Not a problem. Is there anything further you wish me to hear?
City does not.
Okay. Is there someone here for the owner? The owner is identified as All American Oil LLC.
Yes, I represent the owner, All American Oil LLC.
Could you give me your name, please, sir?
My name is Chirayu Patel.
Great, Mr. Patel. Did you hear and understand the testimony of the code enforcement officer?
Yes, sir, I did.
Is that consistent with your understanding of what you would like me to rule today?
Absolutely. I just had a question about the $50 fine. The question is, if I don't get it in 60 days, by chance something happens, will that fine start from today, or would it be after the 60 days?
It would start on the 61st day.
Okay, fair enough.
Would not start today, but I do want you to understand, these are four different cases.
Yes, sir.
So it would be $50 each case. So, I mean, if you didn't do anything, if you did nothing.
It would be $200
It would be $200 a day.
Fair
So I didn't want there to be any, I mean, it's something you want to not forget.
No, absolutely, absolutely. We are in plans of remodeling the place. So
Okay, that's great.
We're going to open it up.
Okay, fantastic. Anything else you want me to?
No, that's it.
Okay, I appreciate your cooperation, sir.
Yep, absolutely.
Okay, the city does as well.
Yep.
Okay.
Thanks.
Okay, I'm going to order.
Thanks for your support.
Yes. I'm going to order in all these four cases, that the agreement reached between the property owner and the city, the property owner being here this evening, that all of these violations will be brought into compliance within 60 days, and that if they are not, that there'll be a fine imposed of $50 per day, and for each day thereafter, the property is not brought into compliance. Thank you.
Thank you.
Okay, our next case is DEL 21099, and that has a property address of 929 Lovington Drive with property owner Hector Alamedina. I apologize if I mispronounced that. City ready to proceed?
Down below you.
Whenever you're ready, ma'am. No, that's okay. I just didn't know if you were waiting for me to say those magic words or not. No problem. Take your time.
Okay, I think I'm ready. My name is Marion Laracy. I'm employed with the City of Deltona as a code compliance officer. This case is in reference to DL 21099, the City of Deltona versus Alamedina Hector J. Property address is 929 Lovington Drive. Parcel ID number is 813-041-040-080. This is in violation of City of Deltona Ordinance Section 37-10, public nuisance, which states all blighted and distressed real properties are hereby declared to be public nuisances, the abatement of which pursuant to the police power is hereby declared to be necessary for health, welfare, and safety of the residents of the city. All statutory requirements for notification of this hearing have been met by certified mail to the property owner at the address listed with property appraisers' records and were posted on the property 10 days prior to this hearing. All evidence in this case, including the photographs, have been marked as exhibits and submitted to the Code Board Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was a proactive case. It started July of last year, 2020. I left notification in September advising of the violation. Mr. Alamedina was in communication to me mostly during this process. He had an attorney and was going through the litigation process. After following the case with the courts, it was found the claim was denied. Since this case has been going on for a year, the violation still remains as of today. I'm not sure what their plan is to remove the tarp. Apparently there is damage, but I'm not able to actually witness that damage because of the tarp. And as of today, the tarp is still on there.
Okay. Is Mr. Alamedina here or someone on behalf? Please, ma'am, come forward. Give me your name and your address.
My name is...
Go ahead, ma'am. Wait till up there.
My name is Deidre Rios, and my address is 456 Northwestern Avenue, Altamont Springs, Florida, 32714.
What is your relationship to the property owner, ma'am?
I am Mr. Alamedina's ex-wife, also have the power of attorney.
Okay. What do you want me to know?
Okay, so there was an insurance claim, obviously, shortly after he purchased the property. There was an issue with the storm coming in and obviously the damage to the roof. We had the unfortunate situation with his insurance company that neglected. Obviously, you know, we have gone through court. Right now, we have literally had like about 5 different companies to go out there and assess what it's going to take to repair it, obviously out of his pocket, because we were just waiting on a decision whether or not he was going to be awarded for the roof repair. We are wanting for at least a 90-day in order for us to have
Sorry,
this.
how much more?
90. And the reason is because I've been calling around roofers. Everyone's busy and everyone's behind schedule because of the weather. So for us to be able to say 60, I don't know when we're going to be out there, when the process of permits with Deltona is. I'm unfamiliar with that, and I obviously don't want to catch myself short with the days to get this done. I personally will have to be paying for that roof. So obviously, I'm the one that's going to be taking charge to make sure that this gets resolved. As far as if there's any existing liens, just going to have to
Let me
figure
make
it
this
out.
one observation. Before you leave today, if you could give Officer Laracy your name and contact information, if you don't already have it, because it sounds like this is the person you want to be working with to get this matter resolved.
Yes.
Okay. That was number one. Number two, what is, the young lady would indicate she'd request 90 days, and I'm curious about the city's position on that.
I'm okay with that. The city's okay with that.
Thank you.
Okay, fair enough. So what I'm going to order today is that the property is in non-compliance. I mean, I think we're all clear on that.
Yes.
I'm going to give you 90 days to bring the property into compliance, or a fine in the amount of, what is the city requesting?
$25 today?
Okay, so it's going to be 90 days to comply,
Okay.
or a fine of $25 per day. And the order is going to state, but I want to make sure, since you're here, when you, I mean, sometimes you can do the work and then forget to do the most important thing. And what the most important thing is, once the property's in compliance, you need to call this young lady right here and tell her that so she can confirm it, because we don't want to, what we want is the property to be fixed. We don't want to impose the fine.
Got it. Okay.
Does that make sense?
Yes.
Okay, so that's the, step one is fix it. Step two is let Officer Laracy know.
Okay. I'll make sure she has my contact
Okay,
information.
fantastic.
Thank
you
you.
for being here tonight, I appreciate it.
you.
Okay. All right, the next case is DEL 21-104. This is property address 2569 Sedgefield Avenue, property owner Miguel Lopez. This is parking. City ready to proceed, sir?
The city's ready.
Please do.
My name is Steve Brockhoff, employed with the City of Deltona as a code compliant officer. This will be case number DEL 21-104, City of Deltona versus Miguel Angel Lopez. Property address is 2569 Sedgefield Avenue. The property ID is 813071320080. This City of Deltona ordinance section 66-19 subsection 3, improper parked trailer, which states that boats, trailers, recreational vehicles shall not be parked or stored either within the public right-of-way or within that portion lying across the full width of the lot between the front lot line and the frontmost part of the principal structure. Statutory requirements for this notification of hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed property appraiser's records. In addition, both notices were posted to the property at City Hall at least 10 days prior to hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the code board clerk. I certify that all the photos be true and accurate portrayals of what I observed the day they were taken. This case began on June 29th when the city received a complaint, and it was passed on to me by my supervisor that parking was bad on Sedgefield Road. So I went up and down, and this was one of the cases I noticed. But I noticed this particular case had been already noticed with the notice of violation by a previous case and previous officer. So I prepared the notice of hearing for to date because the compliance date for that case was March 26th, and the violation either still exists or existed again after the initial compliance date.
What's the status of the property today?
Once again, as of yesterday, it was still there. Today, it was inclement weather.
Have you spoken with the property owner?
No.
Okay. And the violation is that one trailer in their front yard next to their
Yeah, that's
garage and their
correct.
driveway?
It spends an inordinate amount of time out front. If it's allowed to be parked in the driveway, which would be on the hard, 2 days out of 7-day period. However, it's not allowed to be parked in the grass at all, and no vehicles allowed to be parked in the grass.
Is there anyone here for the representing the property owner or for 2569 Sedgefield Avenue? Yes. Ma'am, if you could give me your name and your address, please.
My name is Olivia Perone, 2569 Sedgefield Avenue is where I live.
Okay. Are you the owner, ma'am?
I am fiance of owner.
Got it.
Our trailer's not there, was not there yesterday either. It is in the driveway. Going through contractions right now. I have,
We'll make this quick.
yes, since March 29th. Yeah, since March 29th, I've been back and forth with our fence company. If you see, it's one gate on both sides. We can't get the trailer into the back. I was told by somebody to put gravel there.
Take your time, ma'am.
I don't want to pay to put gravel when we're paying to fix the fence. We are having our third kid. I don't want to spend money and then throw it away because we're going to get fined if we put rock there and then we put the trailer right there. We are waiting on the fence company to come and put the double gate for us to be able to get the trailer into the back. I have called twice. I've left a message. I don't know if it was yours or the previous officer's voicemail. I've left messages. Also with the city, I called the day that you left it on the thing, on the front door. I called, and I never got a return.
Take your time, ma'am.
It's okay. I never got never got a call back.
So where's the trailer right now?
The trailer is in the driveway on the other side of this picture. It's in the driveway backed up. The trailer does get used often when my fiance is home. He's not home right now. He's in and out for work.
Okay, so what's really important before we finish today, thank you.
It's still going to be the same when I sit.
Okay.
Thank you, though.
Before you leave today, ma'am, I want to make sure you understand what the rules are from the city as far as where that trailer can be. I think we're clear that it can't be on the grass.
Okay.
It can't be on the lawn. So that's number one.
Okay.
You fix that, but there are additional rules. Because I don't want you to fix one thing and then realize
Okay.
you did something different wrong.
Okay.
So officer, if you could tell her what the rules are as far as parking.
I don't know where you got the erroneous information, but even if you put a driveway extension in with rock, mulch, or gravel, it's still only 2 days out of 7-day period.
Okay, because
Everything,
of the trailer?
yeah. The trailers cannot be, that's for basically loading and unloading. Driveway extensions are permittable, and that should be for where the truck has been going in and out, so he needs to mulch all that. However, once again, even if you put rock and mulch down there and put in a correct driveway extension, only 2 days out of 7-day period. Beyond that, it has to be behind the front face of the house.
Okay.
So, ma'am, Richard Lovett, let me explain it so to you, and you're not getting the correct information. So you cannot have it parked on the driveway,
Okay.
and you cannot have it parked on the side in front of the front face of the house. Now, if he could pull it behind the front face of the house in the side yard, then that's perfectly allowed.
And that's what we're
So it
trying
would
to do
just
with
have
the
to be,
fence
where
company.
it's at, it would just have to be backed up more to be completely legal where it's parked.
We can't back it up anymore. Our fence is right at the front of the.
So
It sounds like you're trying to get a bigger.
hang on, everybody.
We're trying to get it so it's a double gate instead of a single gate, so we can't open it up to get the trailer into the back.
All right, let's get the record clear. Hang on just a second. That picture is not representative of where the trailer is right now.
No.
Trailer's on the driveway. With the trailer being on the driveway, is the property in compliance?
No,
Why not?
because it cannot be parked in front of the front face of the house.
Okay, that's something she didn't understand.
Yes.
So ma'am, I want you to understand that. It's still in non-compliance.
Mm-hmm.
So it's got to be moved,
Okay.
or else you'll continue to be in violation and there'll be a fine imposed. That seems like that's the last thing you need right now is a
Correct.
fine. Okay, so let's all agree on that. So how much time are you going to need to get rid of that so that trailer is not in your front yard and it's not in your driveway?
We asked the fencing company, and we are in line. It should be within the next couple weeks that we get a set date on when they'll be able to come out to change the fence to a double gate.
So you can't get it in the backyard through the fence the way it is right now?
It is a single, it's a single gate.
Okay.
You can only walk through it. I can't even fit a lawnmower.
So how much time are you asking to bring the property in compliance?
2 or 3 months.
2 or 3 months?
That way I can, because we're having the baby any day, and then I need to be able to have the fence company come out and do it.
What's the city's position?
City's position would be, if it's all right with special magistrate, we're just looking for compliance with the ordinance, and we don't wish any extra stress.
Sure. What initiated
We
this?
would prefer to see 60 days.
Was this a neighbor complaint?
Yeah, but this, we would prefer to see 60 days instead of 90
Okay.
maximum.
Okay. Ma'am, based upon the amount of time that's been there, I understand your situation, but I think 60 days is reasonable.
Yes.
So I'm going to find that the property remains in violation. I'm glad we had this conversation because you now understand exactly what has to be done. It can't just be moved onto the driveway. I don't want you to
Well, it got moved onto the driveway because it was used 2 days ago.
but I didn't want you to think that, okay, it's on the driveway, we're in compliance now. I didn't want you to leave with that. So,
Okay.
so 60 days, it's got to get either moved off the property completely or put behind the fence, 60 days, or a fine of $50 per day.
Okay.
Okay.
I would like to add into that some people think if a truck is connected to it, that it's just one vehicle, and it's not, it's still a trailer.
Okay.
Okay. Thank you for being here tonight.
Thank you.
All right. Good luck. That's all I have on my list. Do we have one that's on for a call? Do we have any more cases?
I don't know if they're present.
Because that's the only ones that were on my list.
We did have one that was here, and I don't see her in here. I'm going to go see if she's in the lobby.
Okay, let's go ahead and do that, and then we'll, let me know, because I'm just going to be here.
Okay.
Thank you, ma'am. Okay, we're going to go back to the beginning of the agenda and get through it. First one is on the agenda under old business. We're doing Massey cases right at first, and it's going to be DEL 21036. It's a Massey case, 941 Shorecrest Avenue. It's had to do with a nuisance and debris. Officer Brockhoff. Hey, let me. I got a question before we get started on this. This is a good time to raise this, and I just want to make sure that. As a special magistrate, one of my jobs is to make sure that the cases that we hear are going to be in compliance, and so I just wanted to let people know that I'm sure all of you are aware, but there was a new bill that became law that requires any cases going forward be initiated not by anonymous. So. I just want to make sure everyone's aware of that, because that can raise a defense and can mess up the whole process if someone were to show up and say, well, I want to know who filed the complaint, and it was an anonymous complaint, then that would be arguably a way for the case not to move forward. So
Yes, we've changed our process in the front.
Okay,
and the
just want to
front
make
staff
sure.
is aware.
Okay, sorry to stick my nose in your business, but that is.
But no,
but thank you.
The city understands that there's supposed to be some caveats if it is a public safety issue.
Yeah, absolutely, absolutely. No, it's never simple.
Yep.
Okay, so let's proceed now with this Massey case regarding 941 Shorecrest Avenue.
My name is Steve Brockhoff. I'm employed with the City of Deltona as a code compliance officer. This is case DEL 21-036, 941 Shorecrest. Joseph Esquivel and Juan Esquivel. I'm sorry if I mispronounced
It's
that.
okay, I wouldn't have done any better.
This is a case was heard on April 28th. It's a debris issue, and 30 days was given to bring the property in compliance. Several days before the end of the 30th day, I put a note on the door reminding them that it was only a few days. The property didn't come into compliance. There was some improvements, and then they negated those improvements. I've never been contacted by them, and to date, the property is still in violation in the front end as well as the back, but they haven't contacted me to let me in the back to clear that. The city, it's a total of 61 days at $25 a day, so to date, it's $1,525. From lack of contact and the fact that property has never been come into compliance, the city would appreciate the fine to continue.
No contact with the property owner?
No, I know they've had some legal issues in the past, and sometimes he goes away for a while. But I've given plenty of opportunity. As I said, I left my card.
Is that what it looks like right now?
That was taken on the, I think the 25th, and it's pretty much the same.
June,
yeah,
July?
it goes back and forth. That's just a small portion. There's a lot of stuff behind the front, or around the back fence. In the front, it's quite. There's debris. There's also very messy, but a lot of the stuff is like lawn ornaments and things like that, which are perfectly okay, but then they're intermixed with all of this debris.
Okay. All right, so I'm going to find the property remains in noncompliance, and through today it's 61 days at $25 per day pursuant to the prior order of the special magistrate for a total fine of $1,525. Fine to continue at that per diem amount. Obviously, the city has options as far as nuisance abatement, or if the property is not homesteaded, to come back to me at some appropriate period of time and request for permission to initiate foreclosure of your lien.
Yeah, and my supervisors have been
Very good.
at that.
Thank you.
Thank you very much.
Mr. Reichman, just so we have it on record, we will be proceeding with an abatement on that property, too.
Okay, right. Next case is DEL 21083. It's a Massey. This is regarding 2193 Newark Drive, or excuse me, Newmark Drive.
3193 Newmark.
So looks like this may be two cases?
Mr. Reichman, it's 3193.
What did I say?
21.
My bad.
It's all good.
Okay, we have two cases, two Massey cases, the same property. The first one is DEL 21083, Massey case, 3193 Newmark Drive, property owner Noemi Flores, and this is a debris case. Officer Scott, let's proceed with that one first.
Okay, let me close it. All right. DEL 21083. I'm
Yes,
sorry.
sir.
Officer Jeff Scott, employed by the city of Deltona as a code compliance officer. DEL 21083 for the debris. That property is now in compliance, so I want to withdraw that case.
Okay, just that one case or both of them at this?
Just that one.
Just that one?
Yes, sir.
Okay. So let's proceed to the next case at this address, which again is 3193 Newmark Drive. It's a Massey case, DEL 21085. This has to do with inoperable vehicles.
Correct.
This case is not in compliance.
Correct.
Okay, please proceed.
Okay. DEL 21085. Again, I'm Officer Jeff Scott, employed by the city of Deltona as a code compliance officer. I'm entering into evidence the proper service of this hearing along with the photo of the violation that was taken today. This case was heard on June 23rd, 2021. The order was signed on the 23rd of June, 2021, given 14 days to come into compliance or a fine of $25 a day until the property comes into compliance. The violation still remains at that property. The Scion sedan has an expired tag on it. Before it didn't have a tag, they put a tag on it, but obviously the sticker affixed to it is expired. So it's still in violation.
Okay. This is under section 6656 for inoperable vehicles. What's the evidence that this vehicle does not work?
I can't tell if it's inoperable. Initially, it didn't have a tag at all, and that's part of the ordinance, that it's supposed to have a tag on it.
All right.
But it also has to be current as well.
Hang on just a second. Give me a second, please.
Would you like me to read 66?
No, I've got it. I'm good. Hang on. Okay, just for what it's worth going forward, folks, 6656 says abandoned vehicles prohibited, and I mean, the case is fine, just not on this case, but just from I think a standpoint, if we're alerting people to the case and for purposes of titling these cases, right now it says inoperable vehicles, and this is abandoned vehicles, and you look at the code, and it says, and you cited the right code. It's just that the title is a little misleading. So we're fine. Just want to make that observation. All right, so we've got they're still in non-compliance.
Correct.
How long has it been?
It's been 21 days since the 14th day that was allowed to come into compliance.
And what's the per diem?
$25 per day at $525 right now.
Okay, I'm going to make a determination and make my finding tonight that the property remains in non-compliance and has remained in non-compliance for 21 days beyond the date for compliance in the original order. Therefore, a fine will be imposed for those 21 days at an amount of $25 per day for a total fine of $525, and the fine will continue to run in the per diem amount of $25 until the property is brought into compliance. Thank you, sir.
Thank you.
All right, the next case looks like we have two cases on one property again. DEL 20088 and DEL 20089, two Massey cases. Thank you, ma'am. And Emerson Family Revocable Trust. Did I get that right?
City's ready?
Absolutely. Great. Please proceed.
Okay. This is in reference to DEL 21089. The address is 2271 Weatherford. Owner is Emerson Family Revoc Trust. My name is Officer Laracy. I'm with the Code Compliance Officer of the City of Deltona. It was entered into evidence exhibits proving proper service and a copy of the original magistrate order along with photographs.
I'm sorry to interrupt, Officer Laracy.
Yes.
Make sure I understand. My agenda has that there are two different Massey cases for the same property,
Yes, sir.
088 and 089. Which one are we proceeding on at this point?
This one I was referring to 089.
Okay, we're going to do that one first.
Yes.
Okay, thanks. Please proceed.
This case was heard and the order was signed on June 23rd, 2021, giving 30 days to come into compliance. This one is in reference to an abatement order due to the structures in the right-of-way.
Okay, my agenda says that this is no permit for a structure. 20089. Hang on a second.
The no permit was actually an old case. That was no
Is
permit.
that just a typo?
It's no permits for the structures in the right-of-way.
Hang on just a second. Yeah, I think that must be a typo, because my prior order does indicate that it's a violation of 38113B,
Yes.
which is placement of planes, grass, et cetera, in the public right-of-way.
Yes, sir.
Okay, that's fine. I just want to make sure that the record is clear.
Okay.
Okay, please proceed. Sorry,
That's okay.
just trying to make sure we're on the same page.
Thank you. So this nuisance was observed May 3rd, 2021. We've been working with the resident numerous times in order to get the items removed. They've built up the right-of-way with dirt and palmettos. They have several other structures in the right-of-way to include partial fencing, railroad ties. This was a picture from today, so I'm sorry it was kind of
That's all right.
obscured. And I believe that we put an order in for the city to go ahead and abate the items that are in the right-of-way.
So what I'm hearing your testimony is, please correct me if I'm wrong, that the property remains in non-compliance.
Yes, sir.
And how long has that property remained in non-compliance beyond the date in my prior order for compliance?
5 days.
And what is the per diem?
Well, it would actually be the cost of the abatement.
No, that's a different process. What was the amount?
Oh, it was $25 a day.
Okay, so we're looking at a total fine of $125.
Yes.
Okay.
Do you want me to do it? I'm going to have to say something here. I try not to say anything. We would basically just like to proceed with abatement on this and not go any farther through this process because we're going to remove, there's a sidewalk that the city wants.
It's up to the city.
Yeah, so we
Your
would.
case.
Yeah, we would like to, I just don't know how do we end a case here?
You would withdraw it.
Okay, we'll withdraw this case.
Okay.
Okay?
Okay, yes, sir.
Yeah.
Thank you.
If you can withdraw cases all night long. Okay, did you have another case on this property, 20088?
Yes, sir.
Okay.
This is in reference to structures and items in the setback. DEL 21-088. The address is 2271 Weatherford. The owner, Emerson Family Revoc Trust. Again, Marion Laracy, City of Deltona Code Compliance Officer. All photos, exhibits, proper service, a copy of the magistrate orders entered into evidence. This case was heard and an order was signed on June 23rd, 2021, giving 30 days to come into compliance or a fine of $25 per day until the property comes into compliance. The violation...
Officer, if I could interrupt, are we going to be doing the same thing on this one?
No, sir.
Okay. Just, if we were, then I was going to cut us off. Keep going.
Thank you. The property was in violation from July 23rd to July 28th, a total of 5 days for a total of, $250. The violation is still it still remains. Most of the items are still in the right-of-way.
Let me understand this. So the property remained in violation 5 days beyond the deadline in the prior order. Prior order provided a per diem fine of $50 per day.
I apologize, $25 a day.
25, okay. So we're looking at $125.
$125.
Okay? Property remains in violation, so there'll be a fine as of today of the amount of $125, and it will continue in a per diem amount of $25 per day until the property comes into compliance.
Thank you, sir.
Anything further on this case?
No, sir.
Okay, very good. The next case is still yours. You're not going anywhere.
Okay, I do have.
This is a new case. This is new business. We're not doing any more Massey's. This one is DEL 21068 with a property address of 1057 Angora Street, property owner Maria Font.
Yes, sir. Are we doing the phone call?
Oh, this is the phone call. Got it. Who will this be? Will this be with Mrs. Font?
Mrs. Font.
Okay, thank you.
Your call has been forwarded to an automatic voice message system. 407975055 is not available.
Let's give it one more try.
Your call has been forwarded to an automatic voice message system. 407.
Okay. Tell me a little bit about what the deal was to set up the phone call. Who was in charge of that?
I spoke to Angela. I did speak to the resident today, and she was aware that we were doing a phone call. She has an injury to her back.
Okay. So she was, I just want, this for the record.
Yes.
I mean, I'm just trying to make sure. Who was it that talked to this lady to set up this phone call this evening? Okay, if you could, Angela, could you say exactly for the record who you spoke with and what was agreed?
I spoke with Ms. Maria Font, and I told her that she should be available to answer the call between 5:30 and 7 o'clock. And she said she would be answering the call.
Okay, let's let the record reflect that it is currently 6:33. Effort was made to call her, and there was no answer. For the record, I'm going to ask Angela for you to try one more time, and if there's no answer, then we'll note that accordingly and proceed without her participation.
Your call has been forwarded to an automatic voice message system. 407.
Now, let's let the record reflect that 2 attempts were made to contact Mrs. Font within the time frame that was agreed upon between the code enforcement clerk and Mrs. Font, and both times Mrs. Font did not answer the phone. City ready to proceed?
Yes, sir.
Please do.
Thank you, sir. My name is Marion Laracy. I am employed with the City of Deltona as a code compliance officer. This case is in reference to DEL 21068, City of Deltona versus Maria Font. The property address is 1057 Angora Street, Deltona, Florida. Parcel ID is 813-005-620-170. This is in violation of City of Deltona Section 37-10, public nuisance which states all blighted and distressed real properties are hereby declared to be public nuisances, the abatement of which pursuant to the police power is hereby declared to be necessary for health, welfare, and safety of the residents of the city. All statutory requirements for notification of this hearing have been met. Notice of hearing and notice of violation were sent certified mail to the property owner at the address listed with property appraiser's record and were posted on the property 10 days prior to this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the code board clerk. I certify any and all photographs to be true, accurate portrayals of what I observed on the day they were taken. I have a picture from today. Tarp still remains on the roof. This case began December 2020. I noticed the resident, Mrs. Font, given her the, just watching the house within the 60 days. She explained to me that she has a claim with the insurance company, and due to some discrepancies by the insurance company, the process was on hold. At this time, when I spoke to her this afternoon, she said she had received a check, but apparently it was written incorrectly, so she had to send it back. Tonight, I would just request to give her a little extension to see if she can get everything situated as far as the insurance check's concerned.
Did she, in your conversations with her, Officer Laracy, did you guys talk about how much time she felt she needed in order to bring the property in compliance?
She said at least 3 weeks. 3 weeks. By the time she mails back the check, then she has to get it to the mortgage company for them to sign, and then she has to sign it, and then be able to get the contractor to come out and get the permits.
3 weeks? Okay. Is that acceptable to the city?
That's what she said. I'm okay with 3 weeks. I feel like it would probably take a little bit longer. I would say at least 45 days.
Okay. Why don't we do this? 3 weeks sounds like that's ambitious.
Yes,
to do all that.
I agree.
And I don't want to set her up for failure.
Correct.
So if it's okay with the city, I'm going to find the property that remains in noncompliance, and a reasonable period of time for the property to be brought in compliance would be 30 days.
Okay.
Or a fine in the amount of $50 per day.
Okay. Thank you, sir.
So if she calls and complains that we didn't tell her or didn't get through her, tell her that she got more than she asked for.
Okay.
So she shouldn't complain.
Okay. Thank you, sir.
Okay, the next case is DEL 21090, property address 1480 Pear Avenue, property owner, Mr., I believe this, it's the Hernandez family, we'll say it that way, and Officer Laracy. They like boats.
Yes, sir. Okay, city's ready. Again, my name is Marian Laracy. I'm employed with the City of Deltona as an code and compliance officer. The case number in reference to is DEL 21090, City of Deltona versus Hernandez de Nanales Rosa. The property address is 1480 Pear Avenue. Parcel ID is 813-040-030-090. This is in violation of City of Deltona Ordinance Section 66-18H, the restriction on trucks and other vehicles, which states a maximum of 2 vehicles may be parked on the side or rear yards. Statutory requirements for notification of this hearing have been met by notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records and were posted on the property 10 days prior to this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the code board clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case I bring to you, I opened May of this year. I observed on multiple occasions many vehicles parked on the side and rear yard. Some occasions there would be cars, trailers, multiple boats on trailers.
But some can be, it's just there's a maximum.
2.
2. You're going to have 2 in the side or backyard?
Correct.
Total?
Correct.
Okay.
The owner of this property has been notified several times in the past. He just doesn't seem to want to comply, and the dynamic constantly changes. I have several pictures.
Okay, so there was a deadline in the notice of violation.
Yes, sir. He was not in compliance.
Not in compliance by that deadline. What's the
Correct.
status today?
Still not in compliance.
Okay. What's the city's preferences?
I would like to do 100, to come in and have 7 days to comply. If he doesn't comply within 7 days, we'll do $100 a day.
Have you spoken with the owner?
No, sir. I've made attempts at the door every time I leave notice. No answer, no response.
Okay, I'm going to find the property does remain in violation. The property on a reasonable period of time for compliance will be 7 days, or a fine will be imposed of $100 per day.
Thank you, sir.
Thank you. Okay, our next case is DEL 21092, property address 1130 Deltona Boulevard. This is a parking lot in disrepair. Officer Muse.
Good evening. I will be filling in Officer Myron San Miguel, City of Deltona, with code compliance for Officer Dennis Muse. This is going to be case number DEL 21-092, City of Deltona versus First Union National Bank of Florida, location address 1130 Deltona Boulevard, Deltona, Florida 32725. The parcel ID number is 8130-0600-0021. The violation is Section Ordinance 18-5, adopting the latest edition of the International Property Maintenance Code, Section 302.3. All sidewalks, walkways, stairs, driveways, parking spaces, and similar areas shall be kept in a proper state of repair and maintained free from hazardous conditions. The corrective action that's being requested is to restripe the parking lot to clearly define the designated parking areas. This is a parking lot behind the Wells Fargo Bank off of Deltona Boulevard. The images, as you see above, were taken today. You'll have to forgive the rain a little bit. However, they are clearly worn down. There are no parking lines anymore at this point. Officer Muse started the case on May 23rd, 2021.
Officer, can I interrupt just for a second?
Yes, sir.
I'm trying to understand. Can you read the code again? That they're in violation, of which they're in violation.
Yes, sir. 18-5, adopting the latest edition of the International Property Maintenance Code, Section 302.3, states that all sidewalks, walkways, stairs, driveways, and parking spaces and similar areas shall be kept in a proper state of repair and maintained free from hazardous conditions. They are not in compliance of this due to the fact that it's a hazardous condition and that they're not being maintained in proper
And it's parking
condition.
spaces.
They're
not
parking spaces.
Not parking lot.
Yes, sir. It states parking spaces.
Okay, that's what, I just want to make sure, because again, the agenda says parking lot and disrepair, so.
Correct.
But again, it's the proper code citation, but it's parking spaces.
Yes, sir.
And they just need to have their delineated correctly.
Yes, sir. They need to be repainted.
Okay, please proceed. I'm sorry, I just needed to understand what we were here for.
No, I understand.
Yeah.
Officer Dennis Muse, on May 25th, the notice of violation was hand-delivered to a female at the bank. The certified mail for the notice of violation was returned unclaimed, and there has not been any other responses from the property owner. On July 13th, the notice of hearing was posted. Also, another posting on the door stated that the building was temporarily closed. After conversating with Officer Muse, all attempts have been exhausted in trying to contact the property owner via property appraisers, via several postings and
Is the property
information.
vacant?
From my understanding, the property is vacant, but the ATM is still active. So the bank is closed, but the ATM is active.
Okay.
So it's still being utilized. It's a hazardous condition in the back due to the fact that there are no lines. It offers a lot of things for problems to arise if it's not corrected. And what people are being forced to do is starting to utilize the side parking area, and the hazardous condition that's starting to evolve is them parking in front of the driving lane for traffic to block the stop sign and things in that area.
You took this photo, sir?
I did take these photos. I took both of these photos today. I am not sure why the date and timestamp has not shown up, but I testify that they're from today.
We've got the record, your testimony. Okay, so the property remains in violation.
Yes, sir. The city is seeking a fine of $100 a day, given 7 days to come into compliance. And then after 7 days, if we do not continue to hear anything from them, I would request a $100 a day fine.
So ordered. One observation for the group. There's no one here to complain, but some of the testimony tonight was hearsay. And I understand that if you don't have the officer here, there's not much you can do with that. But I do want, there is law that says that if someone were to object to hearsay testimony, I would have to entertain that objection. So just wanted to, when someone's not here and someone is filling in, there may be some times where we're going to either need to continue it or find another way to make sure that the testimony is based upon firsthand knowledge. Okay? We're fine tonight, but just for future reference. Okay? All right.
Yes, sir.
The order, just for the record, property remains in violation 7 days to comply or $100 per day. That was what the officer indicated. Okay. All
Yes,
right.
sir, that is correct.
Beg your pardon?
That is correct. That's what I indicated.
Okay. All right. Our next case is DEL 21-100. Property address is 1223 Polk Court. Property owner Daryl Royea. Officer Laracy. You're in your keep tonight. Please proceed.
My name is Marion Laracy. I'm employed with the City of Deltona as a code compliance officer. This is in reference to case number DEL 21-100, the City of Deltona versus Roya Daryl L. The property address is 1223 Polk. Parcel ID is 813-038-270050. This is in reference to section 110-501, which states if a use or structure is not expressly permitted in classification, the enforcement official shall not permit such use or structure in the classification unless it is substantially similar to a use or structure otherwise permitted in the classification. The statutory requirement for notification of this hearing have been met by notice of hearing and notice of code violation or sent certified mail to the property owner at the address listed with the property appraiser's record and were posted on the property 10 days prior to this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the code board clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case started July 2020. I left notification of the violation. The neighbors contacted the property owners, and he called me, Mr. Roya called me, and stated that they are out of the state, they're in Vermont, until late October, early November. So I'm requesting an extension of this case until late November.
Asking for a continuance or a a substantial amount of time for compliance?
Substantial amount of time for compliance.
Okay, so the structure or the property remains in violation?
Correct, as of today.
What is the city looking for as far as the time to comply?
Towards the end of November.
Okay. Okay, so
There's
December
snowbirds.
1st?
Yes. Thank you, sorry.
Okay, I'll make an order that the property is still in violation, that there'll be compliance by December 1st or a fine of $50 per day.
Thank you, sir.
Very good. Next case is DEL 21101, 625 Eldron Avenue, and this has to do with improper parking. Please proceed.
Okay, thank you, sir. My name is Marian Laracy. I'm employed with the City of Deltona as a code compliance officer. This case is in reference to DEL 21-101, City of Deltona versus Avalo, Eusebio, Guferio, Delecia, and Giovanna Jolie Avalo. The property address is 625 Eldron. The parcel ID is 813-041-320-180. This is in reference to, oh gosh, I apologize.
Parking.
Yes, 66-19-3, which states that boats, trailer, recreational vehicles shall not be parked or stored either within public right-of-way or within that portion of the lot lying across the full width of the lot between the front line and the most part of the principal structure. This case began in June. This particular case began in June. I noticed a commercial dump trailer in the right-of-way. I was able to obtain the tag information, and according to the tag information, it belongs to the resident that lives at the 625 Eldron. I left notification at his property. I also learned that he has a construction company registered to that property as well.
So hang on a second, I'm sorry to interrupt. Is the vehicle parked on a property that's not owned by the owner of the vehicle?
Yes, it's parked in front of a vacant lot at a corner, Preston and Fort Smith. There was also another occasion I was out, I ran across another one of his trailers, different from this one, ran the tag and it went back to his address as well. That one was parked on a different vacant lot further down on Brimhall.
Are these vacant lots close to where he lives?
Fairly, yes, they're in the same blockage.
So he's just parking his business vehicles
in various areas
around the neighborhood?
Yes, sir. That's what it seems to be.
Interesting.
I have not had any contact with the resident. I've attempted to contact the resident on a couple of different occasions, and that was unsuccessful. So at this time, he is in compliance. He was in non-compliance by the date that he was supposed to be. He is in compliance today. So I would like to put him in non-compliance and in compliance, and that way he can come back as a repeat.
Very good. All right, I'm going to find, based upon the evidence that I've heard this evening, that the property remained in non-compliance beyond the deadline set forth in the notice of violation, but that the property has come into compliance by the date of tonight's hearing, and if there is another violation of the same ordinance within 5 years, that will be considered a repeat violation.
Okay, thank you, sir.
Thank you. Next case is DEL 21102, which property address 1558 April Avenue. Property owner is Del Toro Construction. And we have two cases on that property.
Yes.
First one is sidewalk, and then the second one is a permit issue. Officer Brokoff.
My name is Steve Brokoff, employee with the City of Deltona as a code compliance officer. This will be case number DEL 21-102, City of Deltona versus Del Toro Construction, LLC. Property address is 1558 April Avenue. Property parcel is 813014110100. This is a violation of City of Deltona Ordinance Section 18.5, citing the International Property Maintenance Code 302.3, Housing Code Driveways, which adopts the latest edition of the International Property Maintenance Code, which states that all sidewalks, walkways, stairs, driveways, parking spaces, and some areas shall be kept in proper state of repair and maintained free of hazardous conditions. Statutory requirements for this notification of hearing have been met by the hearing, the notice of hearing and notice of violation were sent certified mail to the property owner listed at the property appraiser's records. In addition, both notices are posted at City Hall and at the property at least 10 days prior before this hearing. All evidence of this case, including photographs, have been marked as exhibits and submitted to the code board clerk. I certify that all the photographs be true and accurate portrayals of what I observed the day they were taken. This case began May 16th when the city received a complaint regarding a sidewalk in disrepair and also drainage.
So let me interrupt. This is, if I could, just for future reference. And again, I'm sorry to stick my nose, but in the future, when we're trying to comply with this new law, and we come to that point right there, that the city received a complaint, it probably would be helpful for the record just to go and indicate, well, that it was received by not anonymous.
Steve.
I don't have to have it in the record, the exact name, but I think it would be helpful to have in the record that this was received, by someone who identified themselves consistent with the Florida statute, something like that, just for the record.
I understand that one. On this one, the complainant is the city. They were going to build a house. They paid in and put some fees in to build a house. They asked for those fees to be refunded. We went out there and looked and said, you need to correct these violations before we'll refund, and they stopped talking to us.
And that's fine. That's what I'm saying. That would be very helpful for the future, that this was, as long as it's not anonymous, that's all we care.
And beyond
so this one was the city brought this.
Well, the city brought this, and the case following, though, the property owner on the left of the property, as you're looking at it from the road, was the one that complained about the drainage. I don't have a problem with it tonight, but I mean, I just thought for purposes of when we do this in the future together, that this would be the point in time where we can show compliance with the new law. We will comply.
Okay, please continue.
Yeah. Anyway, upon arrival, though, I found that site preparations were made for property. The property owners subsequently canceled the permit. They had a permit to do the work, prepare the site, build a house. In the process of that, they moved a lot of machinery over it that crushed the sidewalk. I contacted a realtor in the case, and he said he was in contact with the builder and they would take care of it. Nothing was done. On May 31st, I contacted the permit department, and they stated that they were in contact, and like my supervisor said, that the owners were requesting some of the fees be refunded to them since they weren't going to build. They were told that, yeah, that would be fine, but the property would have to be brought into compliance, meaning that the sidewalk would have to be repaired, the site itself would have to be stabilized. So nothing happened. I gave plenty enough time for them to comply or work on the property. There's been nothing done at the property, so I posted it with a notice of violation, giving him up until the 26th to comply. This is the 28th. I also posted the notice of violation, notice of hearing at the same time. I was by there just before the deluge hit, and nothing has been done. The sidewalk is still crushed. The property still is in disrepair.
All right. As to this first case, DL 21102, the property remains in violation. How much time is the city looking for
The city would like 30 days before a fine continues, and we would request at least $100 a day because it's a possibility of a trip hazard. The issue that we have is if we would try to go in the city and repair that, and then they would come in and try to come into compliance with the site, which is the following case, they'll recrush the sidewalk.
Fair enough. So let's talk about this. $100 a day is fine. I have no problem with that. 30 days. We're looking at a dangerous condition where it's...
Yeah, I agree. Oh, I'm sorry, Mr. Reichman. We're trying to learn as we go here, and I think we'd like to withdraw this case and go through the abatement process quickly.
Would that be in the following case as well? So that city will shore up the site, make sure there's no drainage issues.
We'll go in and fix what we have to fix, and then we'll go through and,
Because-
put it on the non-ad valorem tax roll on the property.
Okay, because
or
the
cost.
site itself, there's drainage issues because it was prepared and then not finished. It's got to be brought back into some kind of state of composure to where it's not going to allow drainage, which is going to be
So
the...
let me
I
make-
understand, but you don't have to explain it to me. I mean, we have an obvious safety issue, and so we have, that's the very essence of nuisance. So,
And I totally-
we have an obligation to fix it.
All right, just for my purposes, what I'm hearing the city tell me this evening is that these two cases regarding the property at 1558 April Avenue, both those cases this evening are being withdrawn. And the grounds for that, not that I need grounds, but the grounds that are stated for the record is the city is going to proceed with nuisance abatement, the nuisance abatement process for the matters that are set forth in these two cases. Okay,
Yes.
very good. Okay, so those cases are withdrawn, which means we can move on to the next case, which is DEL 21105, Officer Scott. This has to do with 2570 Coachman Drive, property owner Fred Jones. This is a storage issue.
Yeah, well, I just got it today,
Yes. Thanks, Angela.
but, I mean, we have now public.
Whenever you're ready, officer.
My name is Jeff Scott. I'm employed by the city of Deltona as a code compliance officer, and my credentials are on file with the city. This will be DEL case number 21105, the city of Deltona versus Fred Jones. The property address is 2570 Coachman Drive. The parcel ID is 813-05-406-0210. This is a violation of City of Deltona Ordinance Section 38-114, which states that storage of building materials, commercial and industrial equipment materials, objects of waste relating to commercial or industrial uses, or any equipment materials or objects that are not incidental to a residential use shall be prohibited. The corrective action to fix this violation is to remove the septic tanks and other commercial materials from the property. The statutory The statutory requirements for the notification of this hearing has been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's record and posted on the property. In addition, both notices were posted at City Hall at least 10 days before this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the hearing clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This case began on June 10th from a resident advising outdoor storage at this address. I went by on June 18th and observed the septic tanks in the rear yard and other commercial materials. We have been out here to this property numerous of times for the same debris violations, and he'll clean it up, then bring stuff back.
I'm sorry, could you repeat that last part again?
He would clean it up, come into compliance, and then he'll obviously start over again. So
Okay.
this is why we're here today.
So the property, well, keep going.
I'm trying to find, it's like it's deleted.
Is the property in compliance at this time?
No, sir. I had photos here, but don't know what happened to it.
When was the last time you inspected the property, Officer Scott?
Today.
Can you tell me what you saw out
Here,
there today with regard to the
Thank God I have it printed out.
So let the record reflect that I'm being handed the photographs taken today of the condition of the property of case DEL 21105. Thank you, officer. Appreciate it. These photographs taken today show that there is quite a bit of material still stored on the property, which would be in violation of the code, section 38-114. Please proceed, officer.
Okay, sorry. I had it on a flash drive. I don't know what happened.
How much time is the...
So the city requests 7 days to come into compliance or fine them for $100 a day.
Have you had any contact with property owner?
Not for this particular case, but in numerous cases that we had at his house, yes. So he was explained of...
Okay, I'm going to find the property remains in noncompliance at the date of the hearing, that the property owner will have 7 days to comply with this particular requirement, and this order for outdoor storage or a fine in the amount of $100 per day will be imposed thereafter. Our last case is a repeat case, potential repeat violation, DEL 21106. Property address is 2570 Coachman Drive, and that one does sound familiar. And this is Officer Scott again. We got parking.
All right. Oh, yes, like I said, I found it now. Almost at.
Too late. Go ahead, Officer Scott, when you're ready.
Okay. My name is Jeff Scott. I'm employed by the city of Deltona as a code compliance officer, and my credentials are on file with the city. This will be case DEL 21106, repeat case DEL 16236, the city of Deltona versus Fred Jones. Their property address is 2570 Coachman Drive. The city, parcel number is 813-054-06-0210. This is a violation of the City of Deltona Ordinance Section 6618, 6618H, restrictions on trucks and other vehicles, which states a maximum of 2 vehicles may be parked inside or rear yard. The corrective action to fix this violation is to reduce the number of vehicles in the side or rear yard to a maximum of 2 vehicles. The statutory requirements for notification of this hearing has been met by the notice of hearing and notice of code violation were certified mailed to the property owner at the address listed with the property appraiser's record and posted on the property. In addition, both notices were posted at City Hall at least 10 days before this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the hearing clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. While I was there for the debris case, I observed the 2 minute vehicles, the boat on the, hold on, let me pull the photos up here. the boat on the right side of the property, the RV on the left side of the property,
Okay, so let me
and the
interrupt.
trailer in the rear yard.
Okay, so the violation is that there's more than two.
Correct.
All right, so based upon the evidence that you presented, there's been violations, repeat violations.
Correct.
Where you have 3 vehicles.
Correct.
In violation of the code.
Correct.
Farron, how many days did the property remain in that violation?
It's in violation as of today. I'll have today's photos for you.
This is a repeat violation, so I do need to know how many days prior to today that property remained in repeat violation, or was in repeat violation. See, because a repeat violation starts with the date that you first find. If that's what the city's asking for, it starts with the first day the property started in repeat violation. So, I mean, if that's
Back
the
in
city's...
2016.
No, what day was your case open that you noticed it in violation?
Oh, I'm sorry. July 8th. That is, yeah. See, here's photos from July 8th.
And it's your testimony that the property remained in repeat violation from July 8th through today, the 28th?
Yes, sir.
Okay. Anything further? Let me ask this question. Have you spoken with the owner on this particular matter?
Yes, he has been spoke with during previous cases. We have been dealing with him.
No, I
He
mean,
knows the
my
ordinance.
question is, have you spoken with the owner about this?
Not this case, no.
No, not this case?
No, sir.
Okay. Okay. He was noticed of today's hearing?
Yes.
Okay.
It was
Anything
posted on the property and sent to his property.
Okay. Anything further on this case, Officer Scott?
No, sir.
Okay, I'm going to find that the property initiated in repeat violation on July 8th, continued in repeat violation through today, and it remains in a repeat violation, and that therefore a fine will be imposed for $100 per day since July 8th through today, and will continue thereafter at $100 per day. All right, as far as my agenda goes, that's it. Anything further from the city?
No, Your Honor.
All right, thank you very much. We are done, adjourned.